All right, wonderful people, welcome back to this wonderful channel where we'll bring you back-to-back updates and information as to the hot. In case you have not joined our social media handle, what are you waiting for? Kindly go ahead and subscribe, like, comment, share, and also remember to on your notification button so that whenever our news drop, you will be the first we'll collect them. Let's go down to the news proper as it is hot. You don't shall remember that today there is ongoing today is the D-Day for Mazi Nnamdi Kanu's court appearance. As it be, security don't dey tight as Mazi Nnamdi Kanu's trial resumes. The NIG government has decided to keep a tight security as the commencement of Mazi Nnamdi Kanu's trial at the Federal High Court resumes today. Let's go down to the full detail of the information. But before I go down, I will remind you what happened to Jesus when Herod brought security, everybody to close the grave. But last, Jesus Christ woke up in 3 days. If like saying so it go be for Mazi Nnamdi Kanu. As it be for my spirit, I just the few say the right time has come. That person where God destined say in go dey big, that person must dey big. Make we go down to the full detail of the information. There is heavy security presence at the Federal High Court in Abuja, where the federal government is set to resume the trial of the detained leader of the indigenous people of Biafra, Mazi Nnamdi Kanu Ohanezendigbo, one of Ndigbo. All routes leading to the court, which is beside the headquarters of the Federal Ministry of Justice, have been cordoned off by army security operatives. Only those whose names were on a list held by operatives of the Department of State Service (DSS) were granted access to the court premises. The Supreme Court had on December 15, 2023, granted the FG the nod to proceed with the trial of the IPOB leader who is facing charges bordering on terrorism and treasonable felony. The Appellate Court vacated an order of the Court of Appeal that not only quashed the charge but equally ordered the release of the defendant. The IPOB leader, who was first arrested by security agents in Lagos on October 14, 2015, has been in detention since June 29, 2021. Trial Justice Binta Nyako on April 25, 2017 granted him bail on health grounds after he had spent about 18 months in detention. Upon the perfection of the bail condition, he was on April 28, 2017 released from the Kuje prison. However, midway into the trial, the IPOB leader escaped from the country after soldiers invaded his country home at Afaruku Ibeku in Umuahia, Abia State, an operation that led to the death of some of his followers. Nnamdi Kanu was later rearrested in Kenya on June 19, 2021, an extraordinary rendition back to the country by security agents on June 27, 2021. Following the development, the trial court on June 29, 2021 remanded him in custody of the Department of State Services, DSS, where he has remained till date. However, Trial Justice Nyako on April 8, 2022 struck out 8 out of the 15-count charge that FG preferred against him on the premises that they lacked substance. In the said count, the federal government had alleged that Kanu, through his media broadcast, incited members of the public not only to stage a violent revolution, but to attack police officers and also destroy public facilities in Lagos State. The federal government alleged that he had, in his broadcast that was received and heard in Nigeria, issued a deadly threat that anyone who flouted his sit-at-home order should write his or her will. He told the court that as a result of the threat, banks, schools, markets, shopping malls, and fuel stations domiciled in eastern states of Nigeria were not open for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded. It further alleged that Nnamdi Kanu had on diverse dates between 2018 and 2021 made a broadcast received and heard in Nigeria. inciting members of the public to hunt or and kill all Nigerian security personnel and their family members, thereby committing an offense punishable under Section 1, Bracket 2, Bracket H of the Terrorism Prevention Amendment Act 2013. More so, FG alleged that Kanu directed members of the IPOB to manufacture bombs. He told the court that the defendant had, between March and April 2015, imported into Nigeria and kept in Ohanezendigbo in Hiara local government area of Anambra State a radio transmitter known as Trans 50L concealed in a container of used household items, which he alleged declared as used household items and thereby committed an offense contrary to Section 42, Bracket 2, Bracket A of Criminal Code Act Cap C-45 Laws of the Federation of Nigeria 2004. Notwithstanding the pending allegations, the Abuja Division of the Court of Appeal on October 13, 2022, ordered Kanu's immediate release from detention. In a unanimous decision by a three-member panel, the Appellate Court quashed the entire charge against the detained IPOB leader before the High Court. The court said it was satisfied that FG flagrantly violated all known laws when it forcefully rendered Nnamdi Kanu from Kenya to the country for the continuation of his trial. It held that such arbitrary use of power by the Nigerian government divested the trial court of jurisdiction to further try this appellant. Dissatisfied with the decision, the federal government took the matter before the Supreme Court, even as it persuaded the Appellate Court to suspend the execution of the judgment pending determination of its appeal. Likewise, Kanu, through his team of lawyers led by Professor Mike Ozekhome San and Mr. Ivaji Ejiofor, also approached the Appellate Court to query the legal propriety of the order that stayed the execution of the verdict of the Appellate Court. In its judgment, the Appellate Court faulted the Appellate Court verdict, saying it was based on sentiment. In the lead judgment that was prepared by Justice Gaba Mohammed but read by Justice Emmanuel Agim, the Appellate Court held that the Court of Appeal did not anchor its decision on any extant law in the country, but on international statutes that Nigeria is signatory to. As far as Nigeria is concerned, the lower court did not cite any Nigerian authority. The Appellate Court noted, even as it slammed FG for acting irresponsibly when it bypassed the law to bring Kanu back to the country for the continuation of his trial. Be that as it may, what is the position of the Nigerian law, where an accused is saying an illegality has been committed against me? It is like saying that an evidence should not be admitted because it was illegally obtained. Our law is that, notwithstanding the procedure, it is still a valid evidence before the court. If the police arrest a defendant, torture them, and illegally obtain evidence, does it divest the trial court of its jurisdiction? The court queried. It held that the remedy open for Kanu was for him to institute a civil proceeding against the federal government. That is the position of the Nigerian law. The Appellate Court held, adding that the judgment of the Appellate Court, though noble, still remained within the realm of sentiment. Insisting that judgment in such a case must be based on express legislation, the Supreme Court said it found no reason to align itself with the position of the Appellate Court. There is no legislation in Nigeria that says the trial court will no longer have jurisdiction where prosecution does anything illegal against a person standing trial. If prosecution destroys someone's home in search of evidence, that will not stop the trial, but will raise a cause of action. We decline to go to the Court of Appeal, inasmuch as we strongly condemn that the prosecution did. Nigeria must be concerned about its image, both locally and internationally. If a person is standing trial, why must you invade his home? That is totally irresponsible, the Appellate Court added. It held that the federal government ought to have approached the trial court if it felt that Nnamdi Kanu breached his bail condition. Besides, it held that the High Court acted wrongly when it revoked the initial bail it granted to Kanu, saying the action was totally unfair since he took a flight to save his life. Nigeria barely recovered from the case of Nnamdi Kanu, and we should not repeat it. The Appellate Court warned as it upheld federal government's mark SC/CR/1361/2022 and dismissed Kanu's cross-appeal marked SC/CR/394/2022. It ordered Nnamdi Kanu to go back and defend himself on the 7-count charge that is pending against him. Kanu reportedly sacked his legal team after the judgment. And so it be for the federal high court today. It on the shell. I tell you, say, I go to bring you information as the court proceedings do they go. Because na me be your man, we be say it there for inside, we're going to give you information for the outside. Make I wind down the curtain here. There are still more coming on your way. Thank you for listening. God bless you.